I will talk about my take on law and technology, and specifically how I decided to teach it here at UC Berkeley. As Annie mentioned, my specialty is in financial regulation, and a couple of years ago, when I moved here to California, I had the opportunity to teach new courses, and I thought that law and technology was a good idea. And so it took me actually 1 year studying the topic to get to the point where I was comfortable teaching it. And the starting point to teach a course for the first time is, of course, to try to understand what people are doing when they teach law and technology. And I've come to the conclusion that there are two types of law and technology courses out there. The first one is when people ask the following question: how is a certain field of law impacted by a technology? And so instructors will discuss IP mostly, but also constitutional law, especially privacy and contract law, and all sorts of, and all fields of law, and try to understand how the technology is changing the law. Then the second kinds of courses that I have found is a discussion of how certain specific technologies are being regulated. And so you find cyber law and blockchain law and internet law and so on and so forth. So the first idea is to ask, how is a specific field of law impacted by technology, right? So IP is always like a great starting point. How is, patent law or copyrights being impacted by new technologies? The other one is to ask about how the law should discipline specific technologies. And I've come to the conclusion that both approaches are not a discussion of law and technology proper. They are not a discussion about how the law relates to the technology, which is a more abstract question. These are discussions about different approaches, right? So there are discussions about how a law field is impacted by the technology, how best to regulate a certain technology, but they still fail to tell us how the law relates to the technology. And the main question I've concluded in the discussion about the relationship between law as an abstract idea and technology as another abstract idea, the main question in this relationship goes like this. The question is, does technology determine the social context, including, of course, the law? Or rather, does law, alongside, of course, other social forces, tradition, culture, politics, but does the law determine the technology? So can we, in other words, can we even regulate technology? Or rather, is this all an illusion? Is it not the case that technology is simply driving us in a certain direction? So this is the question that I decided in my course to address. And I want to illustrate how this plays out concretely, since we lawyers, at the end of the day, we only understand concepts in an applied fashion. We are not so good in coming up with philosophical ideas, but we are very good in trying to understand how these abstract ideas incarnate in the concrete institutions that regulate our life. And today I will illustrate this question, this tough question, by discussing family law. Let's consider the problem of recognition of children, okay, and specifically fatherhood. Fatherhood is important, for example, for the purposes of inheritance, right? There is a person who claims to be the son of a certain man and therefore claims an inheritance right. Okay? Well, how does the law deal with the problem of fatherhood? We lawyers, especially like myself, I've moved to the US, but there's some things we carry with ourselves from where we come from. And we like to start addressing questions by asking how they were regulated in Rome. And how was the problem of fatherhood regulated in Rome? In Rome, the idea was that the father is always uncertain. Pater semper incertus est. The father is always unknown, incertus, uncertain. And so, how did the Romans deal with it? Well, the law was that the father is the person to whom the marriage points. If the kid and the father look completely different, it still doesn't matter. The person who is married to the mother who gave birth is the father. We would call that today a conclusive presumption or a presumption uri et de jure, okay? A presumption that no matter what evidence you can come up with, it will not be rebutted. If you can prove that the person to whom the marriage points had not seen the mother who gave birth in the past 5 years, and therefore could not be the father from a biological standpoint, it doesn't matter. The Romans said that guy is the father. And modern family law used to ascribe a presumption that the husband is the father with few possibilities of rebuttal. So, for example, if the father was traveling or incapacitated during the relevant months before the birth, then the father could say, well, I'm not the father. When I went to law school in the 90s, I learned civil law or family law along this line. However, nowadays you go to CVS and you can buy a DNA test. So the question is, do these conclusive presumptions still make sense today? Given that for 20 bucks, 30 bucks here in CVS, you can test DNA. Well, the coming about of this new technology has made the old presumptions look silly, unnatural, absurd. So it looks like when you look at the shelf on CVS and you see the medicine that you can buy for 20 bucks and tells you whether that person is biologically at least your father or not, right? It looks like technology is steering the law because the law has changed. We have done away with those presumptions. And nowadays, DNA testing is the law of the land here in the US, in Brazil, and in most places. So the change in the legal solution to the problem of fatherhood, when we look at this, medicine, the DNA test and the shelf, it just seems inescapable. It seems cost efficient, practical, even natural. It would be absurd to rule the problem of fatherhood otherwise, given the coming about of this new, cheap, and very secure technology. But this idea that technology is steering the law can be contested. And so let's look at another problem. Let's look at the problem of motherhood. And let's start again in Rome. So in Rome, the idea was that the mother is always certain, the father never. Mater semper certa, the Romans said. The mother is always certain. The mother is that woman who is giving birth, right? Or is it really? Well, nowadays we have a new technology, in vitro fertilization. And because we have in vitro fertilization, we're going to have the genetic mother, but also the surrogate mother, right? The surrogate mother is the person in whose womb the fetus will develop, and that person will give birth, but might not be the genetic mother. Okay, so this is not a new technology. 30 years ago, in 1989, a surrogate mother here in the US called Anna Johnson, she claimed to have bonded with the baby in her uterus. She felt like the baby was hers. And therefore, she filed a lawsuit to be declared the mother of the child, not to the detriment of the other mother, right, the biological mother, but rather alongside the other mother. And what she wanted was visitation rights, right? So visitation rights is the right granted, for example, to a divorced parent to visit a child in the custody of the other parent. And she said, as the surrogate mother, I want to have visitation rights as well. But the biological the biological father and the biological mother who were married and had originally signed a contract with the surrogate mother opposed visitation rights. And so they started litigation. And the court denied visitation rights. And the reasoning of the court is interesting. The court said that two parents are better than three. And they also applied, this was here in California, they applied California rules on genetic paternity. Let me look at another case. Before moving to another case, let's put ourselves in the shoes of those judges, right? Deciding the case about visitation rights. Is the decision obvious? Couldn't they have gone otherwise? Couldn't they have said, well, the surrogate mother does have a right to visitation? I think the question is difficult. When you look at the fatherhood and the DNA test, it seems absurd to decide who the father is by a method other than the DNA testing. But what about the mother here? Well, let's look at another case. A child was placed in foster care. This is a case 10 years ago here in California. A child was placed in foster care after her biological mother and the only parent listed on the child's birth certificate was incarcerated, okay? Because the biological father was virtually absent from the child's life and was not a presumed parent under the law because the parents were never married. Okay, so the father was out of the picture and the mother was incarcerated and the child was placed into foster care. However, the child's court-appointed counsel sought to keep the child out of foster care by arguing that the child had an additional parent. The biological mother, had a same-sex partner who was married to the biological mother at the time that the child was born. Okay? So how did the court here in California decide? That's a case 10 years ago. The court said, well, we're sympathetic to the situation of this child. We're sympathetic to the claim presented by the same-sex wife of this lady who's now incarcerated. But we are just a court. We can't move first. Under the laws of California, there can only be two parents. And therefore, the court here 10 years ago decided that the child should be left in foster care. Now, in class, what I ask my students is, should this third parent be acceptable? Doesn't it seem that the technology can lead to very different legal answers? Couldn't it be reasonable to accept that in a case like that, perhaps there's a third parent because of the new technology, right? Um, and so in 2013, California enacted an amendment to his family code, which permits the recognition of more than two parents in cases where recognizing only two parents, in this case, the biological parents, would be detrimental to the child. So I'm presenting to you sort of a new world, right? It's a world where the question about who the mother is has become contentious. It's not so obvious. I understand I have half an hour, so I'm going to just tell you about one more case, and then I'm going to get to my conclusion.
No, actually, I'm good. So, we have a lot of time, and actually, I'm enjoying the fact that you're talking about family law and technology. So,
Okay.
be our guest. Don't worry.
And you can take 10 of mine too. I could hear you for all night, so feel free.
I'm trying to move fast. That's all. Okay, so let me just mention a third case. This is really interesting and still not so recent. Okay, this is a case of 21 years ago. It's a 1999 case, and so this is a Supreme Court case, unlike the other ones. So there's this gentleman, Robert Capato, and he is diagnosed with cancer. So fearing that he will become sterile due to chemotherapy, he started to deposit sperm in a bank. And soon after he died, 18 months after he died, his wife, Mrs. Capato, gave birth to two twins. Yes, two twins. Via in vitro fertilization. So what does Karen do? She applies, Karen is Mrs. Capato, she applies for Social Security survivors benefits based on her husband's earnings during his lifetime, okay? So the question, so these kids, they are the children of this deceased man, but they were conceived after this man has passed away. So the question for the US Supreme Court is this: do children conceived by in vitro fertilization after their biological father's death have the right to Social Security survivors benefits? Because survivors benefits normally are for, a man dies, this person has children, this children have survivors benefits. Can you extend this kinds of benefits for the kids that have been conceived after this man has died? And so the Supreme Court says no, they don't have the right. But the point is this: couldn't the court have gone otherwise? Doesn't so when we move beyond DNA, my point is this: it starts to look like it's all a matter of social preferences. And if it's all a matter of social preferences or social choices or values or culture or however you want to call it, then it starts to look like we're moving away from technological determinism. Because you see, the DNA case shows us an instance where it's almost natural, immediate to say, the law moved in a certain direction. Sorry, let me start again. The DNA case suggests to us the technology moves in a certain direction. Now the law has to catch up, right? When you ask students in law and tech, what do you expect in a course in law and technology? Everybody answers the same thing. They say technology is moving ahead. It's changing quickly and dramatically, and the law has to catch up, right? So that's why Annie agreed to titling this talk, is the law catching up with technology? Because this is the baseline for everybody, right? Technology is changing and the law has to catch up. But when you say that the law has to catch up, what it implies is that the law should move in a certain way that's sort of obvious or natural or efficient or inescapable. But when you look at other cases, then, well, it starts to look like it's all a matter of social preferences. And so now, after we've heard all these examples, we're inclined to say, no, it's not a matter of technological determinism. Our values guide everything. But I want to give you pushback on this idea as well. Is it really true that it's all our values? Is it not the case that technology is steering us in a certain direction? Well, let's ask a question that is very common in the field called the economics of family law. The question goes like this, or we don't even have to, talk about theory. Let's just use common sense. Let's ask the following question. Would there be a sexual revolution and thus greater cultural tolerance over different types of family without the invention of the pill? Forget, imagine society nowadays, but a certain technology is absent, the pill. Would our families, our values, and our social preferences be the same? Let's ask another interesting question. Hasn't technology changed the structure of production in a way that gender inequality becomes just absurd? Or to put it differently, hasn't technology changed the structure of production in a way that gender equality becomes natural? You see, in the past, what was, work that could be done, let's say, outside of the household? It's basically carrying logs, construction, and it's manual labor. Well, I can tell you this, men are on average like 10% larger than women. They're physically stronger on average, right? And there's no question about it. They are on average a little larger. So there is a competitive advantage for men to do paid work outside of the household. But with the new technology, the jobs available for everybody are, for example, being an attorney. So in being an attorney, the fact that the man is on average 10% larger doesn't make any difference. So you could say, well, as women's labor force participation patterns increasingly resemble those of men, the comparative advantage in household production might fall on either the husband or the wife. If you have an abler woman, she can do, let's say, paid work outside of the household while the husband takes care of the kids. And by the way, for a number of reasons, many people don't even want to have kids. In part because they just marry older. And they marry older because the patterns of production have changed so dramatically. There's more, right? There are still let's look at family law again to sort of recuperate a little bit the argument that technology is steering the law. There are still substantial costs to breaking up a marriage. If anybody who has been through a divorce, in their family, with their friends, or him, or with him or herself, knows that breaking up a marriage is costly, it's painful, etc. Okay? But the point is this, that this costs for breaking up a marriage, they are now considerably lower, both for women and for men. They are lower for women because the women can do paid work outside of the household. She can support herself outside of a marriage. And also for the man, because the man has to pay less alimony. And in fact, in some cases, the man will receive alimony after breaking up a marriage. And as a result of that, as a result of the new, structure of production that is steered by technological changes that have changed, the way a household is structured, the way labor is produced. I could go on and on and on about why this is so, but I don't want to do that. I think you all got the point, right? As a result of that, as a result of the fact that breaking up a marriage is less expensive for both parties, what happens, we're not going to be surprised with the result. What happens is marriages break up more often. Now, marriages break up more often, and the law changed accordingly. How did the law change accordingly? By shifting away from at fault divorce, right? This idea of an indissoluble marriage, a marriage that is really for life and that can only be broken in few circumstances, to what we have nowadays, which is no fault divorce, right? Divorce on demand. You don't want to be married, you divorce. That's it. And so the point I want to make is this. That's my conclusion. The question about whether technology determines the law, or whether we really have agency and our social preferences can control the direction in which law will go, is an open question. And it's possible to argue both ways. What I do in my course is just to bring up dozens of cases, half of them supporting the first idea, the other half supporting the other idea. Thank you very much.